Hello, everybody. How y'all today? I'm from Massachusetts, but my city is Savannah, but I'm broadcasting from Massachusetts. We have a great show for you today. So good afternoon, everyone, and welcome to your show, Financial Sins, the new podcast on the All Things Relevant Media platform. Now, we're excited about you joining the conversation every Friday at 1 p.m. right here on All Things Relevant Media on Facebook and also YouTube. Now, I'm Mad Flow. You might see my name up there, Mad Flow. Try to figure that out. Mad Flow stands for making a difference for life and others. Because that's what we do all day. I'm not crazy, but I do go by the name of Mad Flow. We got other hosts here today with us today, which is going to be Tanya Scott Pilcher and Anthony Milton. Anthony Murray.
Lost my name. We don't lost her.
I'm Tanya Scott Pilcher.
And my name is Anthony Murray.
Hey, Anthony. And so I help people establish a new career in a $1 trillion industry so that they can live their dreams through training and coaching and motivating them to their full potential. Now, Get Skills just helped 3 young women and a gentleman over the age of 65 complete their first step to financial freedom. We invite others to join our new class that's going to start on April 17th at 10 a.m. at the Empowerment Center in Garden City. And we are reaching our goals, changing our outcome, and changing our income right here in Savannah, Georgia. How about that, Anthony?
That is powerful. That is awesome. Tanya, I like what you're doing.
Woo-hoo.
That's all right, girl.
Thank you.
My name is Anthony Murray, and I am a financial educator. I teach people about money, how money works. And actually, it was my college major, not by choice, but by choice, nevertheless. And I tell you what, I enjoy it because we teach people about some very interesting concepts, rule of 72, X-curve factor. You know that there is actually a wealth formula. We even teach people about that. So we help people learn how money could work for them and their money, your money. All right. And today we have a phenomenal show. Phenomenal. Now, this is like a spinoff or a part 2 of last week's streamcast where we dealt with wills and trust. Now, I hope y'all have some questions. We need your questions. We have questions. I have a lot of questions, but sometimes I may have too many questions. So, right. We want to hear from you, the audience. All right. And with that, we like to introduce our guests, both attorneys, Attorney Joseph Irwin, who is in our hometown, Savannah. Give it up for Savannah.
Hey.
Yeah. All right. So he's local. And then we have Glenn Wagstaff. And Glenn is with a company called Legacy Shield. All right. And they are a national or nationwide organization. And so this is going to be something that is going to help you in and out. There's no stupid question except for the one that you don't ask. All right. Let me tell you that. Right.
So after last week, I kind of went back to make sure that my family had things in order. You know, I'm still not sure. I had a lot of questions. I went back through my parents' paperwork and everything. You know, I'm fortunate to have my mom still with me and willing to work and talk about things in the family, you know, because a lot of African Americans just don't have the discussion about property, about wills, about death, any of that, right? So one of the things that I noticed, and I'm going to get right into it because that
jump into it, girl,
by real quick, is that my father passed away 12 years ago. And so she was just, she had gotten some paperwork in reference to a mortgage, and, you know, the mortgage company had sent her something because a new mortgage company was coming on. And they were like, you got to make some changes here because your husband's name is still on this. And so my question today is, after people, that husband and wife that have a home together and the spouse passes away, what is supposed to happen next so that they can get their wills and their trust and everything in order? Because obviously we dropped the ball 12 years ago. Can you
Good
help?
question. So your question is, 12 years ago, father dies, mother's alive, and how does she get title into her name?
I
And
guess
there's an existing mortgage. Is that correct?
there is an existing mortgage.
Wow.
Here we go.
Uh-oh.
I've got a bifurcated answer for you. Here we go. I also have a mortgage license, by the way. So
Oh,
typically on a mortgage document, you'll see something that says due on sale clause. And usually when you transfer ownership, and let me back up a little bit. Usually when you transfer ownership, it creates a due on sale clause, so it triggers it. So let's talk about the type of deed you have. Going back to what we discussed last week. If the deed is with rights of survivorship, it passes automatically over to mom. So you don't have to worry about that aspect of it, of changing title. It just automatically passes. It sounds like, without having any additional information in front of me, I have to see the document, but it sounds like you do not have a right of survivorship deed, which means that, number one, mom would have to apply probate court to be appointed administrator, or someone had to be the administrator. Two, if this is not a right of survivorship, mom is going to have to qualify to assume that loan.
well,
Wow.
there was like a transfer of, well, I think he wrote something out during that time, like I don't know what to call it, power of attorney kind of thing, and transferring at that time. He wrote something to give to everyone in reference to, I don't know.
I have to see it.
Yeah, okay.
Power of
But
attorney dies upon the person's death.
I
Yes.
understand.
Yeah.
I understand. Okay. So I can't remember exactly what the document was, but the mortgage company asked for that. So our biggest thing now is what?
The biggest thing is going to be to look at the title, see how the property is titled.
Okay.
Second biggest thing is to determine, let's say it's a right of survivorship. That's not a big problem. If it isn't, mom's going to have to qualify for that loan.
Okay, she's going to have to qualify for the loan. Okay.
And that's assuming, I've skipped some parts over, but that means you go to probate court, you have someone appointed as administrator of the estate. You do what's called a petition for leave to sell. You sell the property to mom. Mom now has to qualify for a mortgage to get put it in her name.
Wow.
Yeah, but everybody's scared of that probate court.
Got no choice. No choice. Yeah, can't avoid it.
All right.
All right. Let me ask you guys a question. At what age would you recommend someone to open a will or take out a will or start, have either a will or a trust? At what age?
Go ahead, Glenn. Take that one.
So, I always share this story. When my sister was in college, she didn't own any property. She didn't have any assets. She wasn't married. She didn't have any kids, but she found herself unconscious in the hospital. And the hospital called my parents and they asked them if they had a medical power of attorney. And of course they didn't. And so they said, well, your daughter's here, but we can't tell you anything.
How old was she?
She was over 18, right? So she was 19 years old. And as a parent, you think that these things are automatic. They're not automatic, right? You need to have the right documents in place if you want to be able to intervene in the case of an emergency. So at a bare minimum, we say that virtually everybody needs to have financial powers of attorney and healthcare documents in place. And then once you have children, then in your last will and testament, you can designate who the guardian for your children will be. That's an important decision. So if you have minor children and you haven't designated that person, the law says that any interested party can nominate themselves to be the guardian for your kids.
Really?
So, a lot of times we think that estate planning is most important when you're older. It's actually most important when you have young children and you have a lot to protect, right? And then once you own real estate, then that's kind of the benchmark we look for to say that you really should be looking at a trust plan.
All right. So it sounds like to me, you're saying that when someone becomes of legal age or legally recognized as an adult, they should invest in a will for that purpose, for those medical reasons, so forth and so on.
Or at a minimum, powers of attorney.
Yeah. Minimum power of attorney at least age 18. I believe now we're recognized as an adult. Say that again.
Once you're an adult.
What's the legal recognized age in Georgia as far as an adult? What's the legal age that you're considered an adult? Is it 17 or is it 18? Or is it 16?
18 for an adult, but it depends. I mean, you have a sliding scale. There are certain things that you can contract for and not be 18 years old.
Mm-hmm.
So it depends.
Okay.
You are an adult at 18, but I think for contracting purposes, what Glenn is talking about, entering into a contract, I have to say, I have to agree with him. My note would be, if you have a person who is able to contract, and I think Georgia is 14 or 16, can't remember, if that person has assets, that person needs to have a will if they have assets.
Wow.
Okay.
If that person has a child, I have to say I agree. There has to be something in place that dictates what happens in my untimely demise. I totally agree. But the age of contract in Georgia, I want to say it's 14 to 16. There's certain fundamental services you can contract for at 16, 14. Let me also add this too. The law is always yes or no. There's always this gray area. The other issue would be if this person is an emancipated individual. You can be under 18 but be emancipated. If you're emancipated, you can contract to have a will. So it's a lot of variables in that answer that you're looking for.
Wow.
Right. Wow.
Wow. We have a scenario that we like to pose. Flo, you want to? Oh, well, are you going to be here, Flo?
Yeah, I'll read off on the first scenario. Which one you want, the married or unmarried?
The unmarried one. Let's do the unmarried one.
The unmarried. Okay, so this is where we want to ask a lawyer, and this is going to be some legal scenarios in here and questions that I think a lawyer may be the only person that can basically expound on this right here for us. But the scenario is this: there's an unmarried couple living together since 2001. One passes away with a will. The house belonged to the deceased, but was not willed to the living partner. There's no mortgage on the house. They consider themselves common law husband and wife, and they both have grown children. So can they apply for spousal support? What happens to the home? Do the surviving partner have to leave? What rights do the surviving children have? So those are the kind of, that's a scenario that if you can put something and let us know, and the people out there that's listening, probably we're talking about somebody right now that's this happening to. So if we ask a lawyer, what would you say to this person?
Georgia doesn't recognize common law marriages.
Thank you. We knew that one.
Oh, did you say Georgia does not recognize common law marriages?
We abolished it in 92 and 95.
So that means that the adult children of the one that passed away who owned the house could kick the other partner out.
Yep.
But they would have to go through legal eviction process, right?
Yeah, or just send them a notice and say, hey, you got 60 days to get out.
Okay.
Oh, wow. So they have no rights. Basically, they have no marital rights because they thought they were common law, that they were going to be recognized, and they're not in the state of Georgia. Don't know about other states, but you guys out there, y'all need to check your states and see what the laws are on common law, if y'all still recognized in your states or not. But this person, just basically, rights are being just, after the person passes away, the rights are just being taken away from them as far as the estate, the planning, and unless he had a will or something that was different.
So let me share a couple stories with you that relate exactly to this. We had a situation out in Massachusetts, and there was exactly that sort of scenario, right? Common law marriage. They actually had been married religiously in another country, but never married civilly. They considered themselves a common law marriage. Here in the United States, they have minor children. Husband had everything in his name. I should say boyfriend had everything in his name. Passed away, and then the survivor was hoping that she could continue managing everything. As it turns out, she's not on title on anything, and she didn't have any control. So now she has to go through probate. She wasn't actually married, so she doesn't have any rights to be able to be appointed as a personal representative, except if all the interested parties agree. And so his brother was, being appointed as personal representative. In the meantime, they can't access his business. They can't, sell the house. They can't manage properties, and it becomes a nightmare. And in this case, they had minor children together, and so everything's going to go to the minor children. Ultimately, she's going to be managing it for them. One of the things a lot of times people forget is that if you have a minor child that receives property, somebody's got to be in charge of that, and they have to report to the court every year and say what's being done with that property. There's something called the Uniform Transfers to Minors Act, and that requires that there be a custodian for the property that the minors hold, right? And so she's going to be responsible for it, but she's holding it on behalf of her children. And so there's a lot of hassles that they didn't anticipate, and they just assume that she had rights because she was under a common law marriage. You never assume that you have rights that you may not actually have, right?
Wow.
Two comments on that. Okay, one question is this. If they were living together in 91, would the common law marriage be grandfathered in for those who was together prior to the 91, 92? Would they be recognized as being grandfathered in as common law husband and wife?
My malpractice carrier would call me if I answer that question right now. I'm not going to answer it. I'm not going to answer that because it sounds like this is a specific person answering a specific question, and my malpractice carrier is not going to call me and say you gave someone some information. It depends. The definition of a common law marriage in Georgia used to be, back in the day, you had to carry that person's last name. You had to, everyone in the world had to think that was your spouse. They would look to see if you had electric bills in your name, was there bank accounts. There's a whole lot of variables going on.
Wow.
So I can't answer that question.
Okay. Right. Part two to that is this. On that scenario that you told us in reference to the couple in Massachusetts, everything was in the boyfriend's name. If the surviving partner was to prove that they paid in, say they did pay on the house, they did pay on whatever property they have, if they were able to prove that they actually helped pay for the mortgage, items in this, the mortgage, the furniture, if they can prove that they paid some part of the bill, how does that affect the when the person passes away now? But the person proves that, hey, I put $30,000 in that house and I have checks that I can show you that I actually paid on that house. It's in his name, but I have checks that I can show you. I can show you receipts that I paid for this furniture. It's in his name, but I paid for it. His name, because his credit was better, but I paid for it and I have receipts to show. So what happens in a situation like that?
So what I'll say is that, again, you may have rights for other reasons that are vested for other purposes beyond just the fact that you considered yourself married by common law. And you can exercise those rights. But sometimes those rights, when they're exercised, turn into big legal battles. Another example, we had another client of ours that they had been married for about 2.5 years. When they got married, he had Parkinson's. It was in advanced stages, and he needed ongoing care. His new wife took care of him 24/7 for 2.5 years. And then he ended up passing away in an accident, basically in his hot tub. And this was a situation where they had signed a prenuptial agreement.
Oh, man.
And in the prenuptial agreement, the children understood that the intention was for the new wife to not get anything from the estate. It seemed to us very clear in the prenup that she was intended to get part of the estate, but the wording wasn't, exactly right. And so now you have a fight between his kids and his wife, right? Surviving spouse. And yes, she had rights and we were able to exercise them. And you may be able to exercise those rights, but I'll tell you, it's taken 2.5 years.
Right.
It hasn't been fun. And we finally got to a point where they're collaborating, but you don't want to be in that situation. You want to plan ahead.
Wow. Wow. Well, listen, you said something, Glenn, that was very interesting about marriage. You said a religious marriage and a civil marriage. What's the difference?
Well, the eyes of the law consider, what's registered with the state. And so if you're not married civilly, then it's not considered a marriage under the eyes of the law, except on a case-by-case basis, state by state. And, maybe Mr. Irvin has a better answer for Georgia.
Pretty much.
You hit the nail on the head. I mean, Georgia is similar. A civil union is not a marriage in the state of Georgia, and a marriage is not a civil union in the state of Georgia. So that sort of gives you that way. You have to. A civil union is just a legal document that says you're bound together. Yes.
Well, hey, we have another scenario for you. And there is a married couple with minor children prior to marriage living within the home. Couple is involved in a traffic accident. Husband passes away. Wife survives. Children are wife's stepchildren. House has a mortgage with husband's name only on deed. Husband left no will, no insurance. What's
Double
going
Sounds like
on?
a bar. This sounds like a bar exam question, man. This sounds like a real bar exam question,
Hey, listen, I only studied law for 2 years, but I never pursued. But I didn't come up with the question. A lady named Mad Flo did. And when she says she's not crazy, y'all don't believe that. Don't believe that.
I'm just a little mad. That's all. I'm just a little mad. I'm not crazy.
Ooh.
So how would you deal with a situation like that?
All right, here we go. Person died in an auto accident, correct?
Correct.
Right.
Georgia has a specific wrongful death statute that you have to follow. It tells you under the Wrongful Death Act which person has the right to recover. Start with that.
Okay.
For the death of a child, even if you are an adult and you aren't married, it's the parent. And in this case, you're telling me that he died with a spouse. The spouse or the children have the right of action. That's the first step. It's a complicated response, but here we go. They would set up an estate, and the monies that would come from the lawsuit or whatever settlement will go into the estate. Okay, and that's assuming that everyone's in agreement. I'm going back to what Glenn said about an agreement as to who could be the administrator, who serves in that capacity. You said something about stepchildren?
Correct.
The stepchildren are sitting out there and they want to know, what do they get?
Well, the children, they're minor children.
Mm-hmm.
They're minors.
Okay. But they're stepchildren.
Correct.
And the person that
Yeah,
died,
the
that's
wife
not
kept
his,
the stepchildren.
No,
the person that
That's
died,
his children.
they were
those are
his
his children.
Yeah,
Yep.
they're his children.
his children.
His children would then take through the estate process.
Okay.
They would recover through the estate process. There was a piece of property involved too.
Oh yeah. Yes.
Yes, a mortgage, a
Well,
house with a mortgage. With, yeah.
that goes back to that complicated response that we did last week. It depends how the house is titled that we said earlier, or the
Okay.
house might be sold to settle the mortgage. And to me, going into this whole issue, I think Glenn may have hit the issue a little while ago that since you have minor children, the court would appoint a guardian ad litem to be over the children if the recovery amount or the total estate is greater than, the recovery amount is greater than $5,001. You would have a person appointed as guardian over the person and over the property in Georgia, because you'd have to have that set up that way. Very complicated issue. And if you're talking about selling off the property, you'd have a guardian appointed to that person until they turned 18.
Wow.
Well, let's go back for a second, because what normally happens is that people just don't know what to do. And so, we are to live the American dream. The American dream is to get married, have 2 kids, buy a house, right? That's after you get your job and all of that. And so no one thinks about how it should be. The deed should have anything on it, or the mortgage or whatnot. And so who should have been explaining that to us at the very beginning? Should that have been my mortgage company? Should it have been, where was I supposed to learn it? Okay.
That's the adulting class that they don't give us in school.
Nobody.
Yep.
Right.
Yep.
So in other words, the responsibility is on the person himself to seek the information that they need to prepare for their estate, because it's not taught in the school system, correct? It's not taught in the school system. Yeah. So if we don't take the steps ourselves, and there's a lot of information out there that is at our fingertips, and we fail. So many people just fail to act. They're waiting for someone to tell them, and that's not the way of the world anymore. People have to learn. They have to take the step to learn. My mom didn't teach me, because she only knew what she knew. She only knew how to put money in the bank, and this is it. But when I grew up, guess what?
And all we know is, I'm sorry, Flo.
Yeah. And it's just that I found other avenues. I started, when I listened to people, I took a little bit further and did my own research, and made me a better person because of the knowledge that I obtained about finance. But it's not going to come from our parents. It may come from a wealthy family, someone who's wealthy, and they're going to pass that knowledge and that, that wealth of generational wealth down to their family. But when you're talking about the average person, man, a whole different story. We're not getting what we need. And I just want to say one thing. In reference to that second scenario, both scenarios, it was a lack of preparation from both parties, that basically when one person passed away, they were left in debt. The survivors were left in debt. And guess what? They lost their home. So it was a lack of preparation on their part. And I'm glad we have these lawyers here the lawyer and the representative from Legacy, to give us the information that's necessary for our audience out there to grab hold of this information. It's powerful, absolutely powerful. Go ahead, Tanya.
Yeah.
No, I was going to wait on them to respond before I said.
Let me respond by saying that, in Flo's question at the end, and I don't know if it was part of the question or if you threw it in there, but you said, "Uh-oh." The thing is that I can't tell you how many times people will come after, having to deal with a situation, or when they're just looking for a consultation on what they need to do. And they'll tell us, we thought that there was a problem, but we weren't sure, or we thought that we should have done, or we thought that maybe it wasn't done right, or we thought that we needed something else. And so, you know, our own intuition a lot of times tells us that we should be thinking about these things and planning for them, but we postpone it, we procrastinate it, we forget about it. And so, you know, it's not very often that we get blindsided by these legal issues after somebody passes. Most of the time we have a sense that there's going to be a problem and we just don't address it. And that's the little, you know, angel on your shoulder that you got to start listening to.
That's true.
But let's explain to our audience, what is the step? I buy a house. Okay, I'm in this mortgage contract. I bought this house. So now, what do I think next? And what should I do next? So husband and wife, we got a house. We have 2 children. We've reached the American dream, step 1. Now, what's step 2?
Glenn said it last week. Whenever you get married, have a child, you need to have a will. And when you have a child, you need to update your will. When you acquire a home, you need a will. When you decide you want to get a new home, you might be married, may not be. Update your will. If you get a divorce, update your will. He said it perfectly last week. You know, whenever there's a major life event, if a child dies, update your will.
Okay.
You know, if you acquire a business or you start a business, update your will.
Update your will. Wow. Well, let me ask you something. In conjunction to that, what documents would someone need to bring with them when they go into your office to start a will?
Let's go ahead with that one. I'll be quiet for a while.
So when you do your plan, again, it may be a will, it may be a trust, and
right, either one.
What you're planning on for the future. Most of the questions are not extreme questions, and a lot of times people are surprised by the simplicity of the information that we need. We're going to need names, we're going to need birth dates, we're going to need personal information. And generally, we like to have, you know, the information about what assets you have and where those accounts are and so on. But really, the only documents that you need to track down are the title to your property. So if you have, real estate, you need to find the deeds or find the title for the real estate. If you own businesses, then, you know, we probably going to want to review whatever legal documents you had when you set up the business. So operating agreements or articles of incorporation or organization. And, you know, if you think it's important, bring it with you. And we may not look at it, we may not need it, but bring it with you anyway. But it really doesn't get more complicated than that usually.
Usually.
How long is that process?
So generally speaking, when you sit down and you do your planning, and every attorney is going to have a different process, but you know, once you know that you're moving forward with your plan, generally you have some sort of design meeting, and that may be, you know, half an hour to an hour and a half, maybe even a couple hours, where you talk through all the details of your plan, who you want to serve in what roles, and how you want the plan to function, and who you want to leave things to. And then, generally speaking, if you're working with a professional, they're going to take some time to do your documents, and then they're going to set up a signing meeting for you to get back together or to meet with a notary and actually notarize everything. And that whole process, including transferring all the property and everything into the plan, it may be a month, maybe a couple weeks. But the actual time that you're spending on it is probably only going to be a matter of a couple hours.
Question again. One other question. Great answer. I love what you're saying. I'm hoping everybody's taking note of what's being said here. Now, y'all talk about the will. Great. 2 questions on the will. The original will. Who keeps the original will? Will the lawyer keep the original will? Give the client a copy, or does the client keep the original will? Lawyer keeps a copy. How does, retaining that will works?
I just had this issue this week, so there might be somebody calling in.
I know that was
the client had, here's my thing. The client The client's file is the client's file. That's first step.
Okay.
The client is your client. And if the client tells you they want their original will, they get their original will. If the client requested you keep the will, you keep the will. Typically, you tell the client here in Georgia, you can always file your will for safekeeping at the probate court. So,
Really?
having said that, let me answer part two. Some clients request that you don't keep a copy of anything. I've had that happen. So there is no hard and fast rule about who retains what, because it is the client's property ultimately, and the lawyer works for the client. Therefore, unless that client advises you to do something illegal or unethical, you will follow what your client advises you to do.
Okay.
Wow.
Number two is that people that keep their wills and they tell nobody where it is, then when they demise, then nobody can find it, you know? So they still have to tell somebody where the will is located. And that has been a problem over and over again, that nobody knows where it is. They have no idea who the attorney was that drew it up to even go back. People don't have family attorneys anymore. And older people never had an attorney, you know? And so a lot of times we're dealing with grandmama them, and grandmama them, you know, got some property back in the day when they were able to get some property. However, it now becomes heirs property. And so our parents have all of this property wherever, and everybody's just keeping the taxes paid, but they don't know what else to do with it. They really can't get out of it. They don't even know how to get out of it. They don't know if they can sell it or not sell it. And so, because again, there's no direction. And our grandparents or our great grandparents, they were just proud and happy to get the land or to get the piece of property. And everybody's name is still on it. Grandma, granddaddy from, you know, when they were born in 1920, whatever, or 1900, and those names still,
way back.
you know, so no one can do anything. And what the biggest fear is right now is that you're going to lose that property because everyone won't pay the taxes, or no one knows what to do in order to sell it. But that's what's going on in everywhere. South Carolina, Georgia, Florida, anybody that has grandparents that was proud and happy enough to get a piece of property, they don't know what to do other than to pay the taxes. They don't know how to get anything out of it, get rid of it, or anything. What should we have done? How do we help our parents?
So there are trillions of dollars, trillions with the T of dollars across the United States in unclaimed property that was unclaimed either because people didn't know how to claim it or they didn't know it existed. Every year, there are hundreds of life insurance policies that should pay out to the family, but the family doesn't claim it because they didn't know it existed. So it's important to let your loved ones know that if you have a plan, you have a plan. And, you know, if you have an attorney, let them know who the attorney is so that they can reach out and get information. If you have, you know, important, you know, my grandmother had to move away from her home recently, and my grandpa passed away last year. So when she passed, you know, when she moved away, she was worried about the house because she's a little bit of a hoarder. She has a lot of stuff in the house, and she's worried because somewhere in the house there's money stashed away in the walls. But nobody knows where.
Yeah, I can believe that too. I can truly believe it.
How much, but somewhere in there, there's money stashed away. And that's the last thing that you want to do is for the secret stash to stay secret, because then nobody's going to claim it, right? And so if you have assets and you have, you know, important information or something like that, you want to have a method to be able to leave that to your loved ones, whether you tell them about it during life, or whether that's using, maybe nowadays there's software that can help to transfer that information to your loved ones when something happens to you, and you can keep it private during your lifetime, but then allow them to receive it after you're gone. That's one of the things actually that Legacy Shield does. But it's important to have a method for how you're going to transfer that information, because we get calls all the time of people saying, okay, my husband just passed away and we need to claim life insurance, but we don't know what company it's with.
Right.
There's no way to know. You got to call up all the companies. You got to call up Pacific Life and ask them, did my husband have a policy here? You got to call up, Nationwide and ask them, did my husband have a policy here? And you got to go through those steps, because that's the only way to find out. Unfortunately, for whatever reason, our system doesn't have a better way. So it's on your shoulders.
Hey, well, let me ask you a question. Wait a minute, Tanya, were you getting ready to say something? Let me ask you a question. What happens in the event you're dealing with an attorney, a private individual? He's running a one-man office, one-man shop. Now the attorney passes away. He has your will, all right? And he has all your records, so forth and so on. What happens to that information?
See, that's the other thing that I think a lot of our community ends up doing, is trusting too much that somebody else is going to take care of it for you. And it's great that, if you have a trusted attorney and everything, that, you have that trust with them. But at the same time, you want to have a copy for yourself, because if you decide you want to change things, you don't necessarily have to go to the same attorney. It's probably a good idea to, but you don't have to. But you want to have control over your own destiny. So you need to at least have a copy for yourself and know where it is. A lot of times we rely on professionals, and then, in Las Vegas, they have a crisis right now. They have a whole football field worth of banker boxes of cases left behind by attorneys that have passed away. And they don't have enough manpower to reassign those cases to new attorneys.
Wow.
And if you get caught in that middle, right, what happens? It's going to take a long time. It's going to be a burden on the family, and it can be solved by making sure that you have a copy of your own documents and you know what your plan is, and then let whoever you've nominated in your plan that's going to have a responsibility, let them know that they're going to have a responsibility and that there is a plan.
Doesn't matter whether or not that will, if you have a copy, if it's opened or closed. Because my mom has a copy of her will, and it is in a sealed envelope. And so she was like, I already gave you a copy. This is my copy. And I'm like, well, open it. And it was like, no, I don't think I'm supposed to open it. So we didn't open it. So we don't know whether or not, is it official or not official if we open it, or does it matter?
Doesn't matter.
Doesn't matter. Okay.
Let me ask you a question. Okay, Tanya said something earlier about, people having wills, and they may lose their will or whatever, don't know how to find it. But what can someone submit a copy of a will to probate, not the original, but they have a copy? Can they submit that to probate? And then
Georgia law, yes, you can. Submit a copy. You have to have with it an affidavit that states pretty much that this is a copy, and let me back into that a little bit before I get too far ahead of myself. It is a copy that the person, the testator that wrote the will, did not intend to destroy it. There's some hoops you have to go through, but yes, you can. Short answer.
Wow.
Okay.
And I think it only costs like $15 for us to file our will with probate. I don't believe it's anything expensive. I think we can just go and file whatever will you have in probate. Correct?
You can.
Okay.
I don't know the cost, but you can. Yes.
So then my next question is, I wish we'll get someone in reference to probate, but that's everybody's biggest fear, because you're going to end up, losing something. Is there ever a chance where you gain?
I guess the answer there is yeah. You could always gain. You might find they left some money somewhere in a wall in a house, and you just end up with the money. I mean, yeah.
Time for remodeling party.
Yes.
Yeah, always.
All right. Well, we're at
Hey guys,
10. Go ahead.
I just want everybody to know that I put in the comments a link where you can go to actually find lost a life insurance policy. So it's in the comments. So all of our guests that comes on, I mean all of our watchers out there, look for that in the comment section. And there's a link where you can find a lost policy. All you gotta do is click on that and follow the link, follow the prompts on there.
All right. So Glenn and Mr. Irvin, we want to give you guys a chance to kind of wrap this up for us. We're in our last 10 minutes. We want to, just give some knowledge to our guests in reference to the things that they should do, shouldn't do, or whatever it is that you want to share with them today.
And how they can contact you as well.
Yeah.
I would say don't ever fail to plan. Always plan. Because if you fail to plan, you plan to fail. The key to understanding estates and understanding what you want to do when you leave is left up to you. And if it's me, I would tell a person, you do not want other people making decisions about what you've acquired during your lifetime, where to go. You want to be able to direct that. That's the first thing I'll say. Second thing I'll say is that lawyers are not these big scary people that some people make us out to be. And we aren't the boogeyman walking around trying to, give me all your money and, like a little mass bandit. That's not us.
You guys aren't? Okay.
You can always shop around and find a lawyer that suits your budget. And that's just being honest. Third thing I would say is, the little online wills that you find, the going to is it Office Depot and those places to go get the little generic. No, don't do that because you don't know the law. Don't Google it because you don't know the law. Licensed professionals know the law, and it's always better to have a licensed professional. And I used to tell people, you're going to be a Google doctor if you're sick, or you're going to the real doctor. Which one are you going to listen to? And for some reason, when people come to lawyers, they seem to think that their common sense outweighs the years of school that lawyers have gone to, and it's not necessarily so. Last but not least, I would say that having a will, and I will draw on my background as a pastor, is doing what is decent and in order. Because you want something to be done orderly. Not haphazardly, but orderly. And in my capacity as a Baptist minister, I've seen funerals go completely awry. Mama wanted to be in a pink dress, not a blue dress. Mama didn't want to go to this particular cemetery. Mama didn't want to be cremated. Well, you have a will. You can tell them exactly what you want to do with your body. You can tell them exactly what you want to do with your assets. Lastly, I'm local. I'm in Savannah. My office number is 912-220-3580. I don't charge a consultation fee. If you call and just simply say that you heard me on All Things Relevant, I don't mind. I will not charge you a consultation fee for a quick over-the-phone talk. So just tell me where you heard me at, and that's what we do.
All right. Thank you. All right, Glenn.
So let me just share with everybody, there's a reason that in our country we have differences in multi-generational wealth. And there are some communities that don't enjoy that transfer of wealth from generation to generation in the same way. But a lot of it has to do with failure to plan. And when we start, because if you want to leave a legacy of wealth, of riches, right, it's pretty easy to do. You get a big fat life insurance policy, leave that behind for the family, you can leave them millions of dollars. The problem is without the right guidelines, without the right plan in place, that money can go through your fingers just as easily. Lottery winners don't hold on to their winnings, right? On average, it's gone, whether it's a big windfall from a lottery or from an estate, it's gone within 17 months. And it's crazy to think about, whether it's $10,000 or $10 million, right? The idea is that you want to put in place what's important to you in terms of values and reflect that in your planning. And your plan needs to address those things that are important to you and the kind of legacy you want to leave. And so this shouldn't be a one-time thing that you do it once and forget about it the rest of your life. Estate planning is part of the legacy that you're leaving behind for your loved ones. It's really more about those people that you care about that you're leaving behind than about the stuff. And that's why it's so important. We postpone it because we don't realize the hardship that it could cause our family when we're gone without it. And so it's important to, to address it. It's important to keep it maybe in the back of our mind and review it every few years. We recommend every 2 to 3 years. But it's also important that when you do your planning, don't skimp on the process, because you may be missing out on more than just, the money that you may have saved, right?
Right.
And so it's not worth doing a $100 will and then missing out on all the benefits that the future generations would have received from you if you would have done it right. By setting up a proper plan, you can change the course of your family's genealogy forever. And there are ways for you to be able to, even with a modest. So I have a great aunt and a great uncle, and they were great, but they're also my great aunt and great uncle. They didn't have any kids, and they didn't want to leave, their property to anybody specific, but they wanted to leave it to their church. And so, they never earned very much more than $50,000 a year. They had a pretty modest income and so on and so forth, but they would save up their money, and every few years they would get a new life insurance policy. When that couple died, they left over $15 million to their church.
Wow.
On a modest budget, on a modest income, on a modest situation. Anybody can leave a big legacy if you take the time to plan, if you take the time to, address these things proactively. And so that's what we'd invite you to do. And if you want to get a hold of us, we have attorneys licensed in all 50 states. We can assist with planning all over. And just like Mr. Irvin mentioned, that if you mention, you need to let us know where you heard about us, because that's how you get the free consultation. But let us know that you were recommended by this podcast. And you can reach us at 904-712-LSPN. That's 904-712-LSPN.
Right. Hey, and Mr. Irving, you're not only in Georgia, you also have an office in Florida.
We do, but we only do real estate closes in Florida.
All right, but people need to know that. And so this is important, guys. I hope folks, you are taking some good notes, and keep in mind, you can always go back and look at this again and just review and get that information. And you could call us. All right. You could call Tanya. You could call myself. You could call Flo if you want to know more about what we're going to be doing in the future. And guess what? If you have a particular show that you would like for us to put together, because we know the people, we'll bring the guests in, you tell us and we will make it happen. All right, we will make it happen. Well, we'll do everything we can anyway. If we can't make it happen, we'll let you know that too. All right. This has been a phenomenal podcast today. I am so blessed and so fortunate to be with these wonderful hosts, Tanya and Florence. And we want to thank our guests, Glenn and Joe Irvin, for being with us. And we do not want to forget all things relevant media. Please, man, show them your love. Show them your love. They're on YouTube as well. You could sow seeds into this station, All Things Relevant Media. I don't see the Cash App address, but that should be coming up. So you could actually sow seeds and help All Things Relevant do things, because they reach out into the community. All right. So they're just not doing something on here, YouTube and Facebook. Man, they are doing things in the community. So there's a Cash App address right there, Cash App, and just keep it in mind. All right. Let's make this thing to happen. Let's reach our community. Let's help the people. I want to thank you from the bottom of my heart. Thank you, gentlemen, so much for sharing your expertise, for being here with us. And if you can't reach Glenn and you can't reach Mr. Irving, give myself, Tanya, or Flo a call, and we'll make it happen. Okay, we will make it happen. Gentlemen, we want to thank you, Tanya, Flo. Any last comments? We have to wrap this up.
See you all next week, Friday.
Hey, looking forward to seeing you next week. 1 o'clock sharp, guys.
1 o'clock, and bring a friend.
And have us questions.
Yeah.
Thank you for having us. Take care, guys.
Like us on Facebook. Thank
Thank
you, guys. Take care.
Have a great day. Stay safe.
Don't forget to wear your mask.
I don't have to have a mask. I'm in the room by myself.
Huh, you're in the room by yourself? Oh, yeah. Okay.
Yeah, I'm all in the room by myself with the doors locked.
With the doors locked. Oh, my goodness. Well, I guess so.
My granddaughter would sneak in. My granddaughter would jump in here.
Your granddaughter jump in?
She'll jump in.
All right. What we're doing next week?
We're talking about life insurance.
Life insurance, yeah.
Long-term care. And what is because I put it on the sheet that we had.
Yeah.
Let me see what we
So life insurance, long-term care. Well, you guys be ready. All right, you just be ready. Come with your questions. You have some experts. We are the experts in that area. Okay. So we may or may not bring a guest, but we are the experts in that area. Okay. So if you want to know about that, or if you are involved in that area, you want to comment, we look forward to it. All righty. Thank you so much for being with us today. Join us again next time.
All right, Tasha, you can take us out.
I really enjoyed the conversation today. All right, click leave studio.